Right, back live with you tonight and in focus. The Constitutional Court has granted Parliament an extension to finalise the Electoral Amendment Bill. The Act was declared unconstitutional as it makes it impossible for candidates to stand for political office without first being members of political parties. Daryl Swanepoel of Inclusive Society Institute joins us now for reaction. Daryl, good evening. Good to have you and thank you very much for your time. What then does this mean in this process of amending the electoral bill, that this extension has been granted?
Well, good evening, Tabo. Good to be with you and the listeners. In the first instance, let me just say that there has been some movement on the bill and we have seen some positive improvements to it. However, there are 3 or 4 issues that still remain problematic to the broader civil society. Those issues are the barriers to entry, which makes it very difficult for independent candidates to actually get access to the ballot. The second is that there's a belief that the vote of the independent candidate is not equal to the vote of the political party. And thirdly, there's an issue with regard to the aggregation of votes, where independent political candidates can stand in all 9 provinces, but the votes of the 9 provinces will not be added together, whereas political parties are able to add the votes together. And this goes against the principle of equality, which is enshrined in the Constitution. So whilst civil society, generally speaking, welcome the improvements that have been made to the bill, these elements, we believe, will still render the bill unconstitutional and cannot go unchallenged. And the problem that we have is that it's going to pass Parliament without amending the constitutional flaws, which means there'll have to be a challenge in the Constitutional Court. Now, challenging it in the Constitutional Court in itself will create further delays, and we are worried that that is going to place undue stress and difficulties for the IEC to be able to run a well-run election in time for 2024. And therefore, we are urging the Portfolio Committee, who is now considering the bill in front of them, to please pay attention to the problems, the constitutional problems that civil society have pointed out. Because without amending those constitutional problems, as I said, it will be a constitutional challenge and it will create a crisis for the IEC to be able to render a free-flowing election in 2024.
Yeah. So the barrier to entry question, you are still raising the issue of supporting signatures that are required. You're saying the bar, I suppose you're saying, is set too high in a manner deliberately leaving out independent candidates. What is the adjustment that you are calling for?
Correct. Well, up until now, as the current bill stands, for a political party to register and get access to the ballot, they need 1,000 supporting signatures. Now, in the initial bill that was put on the table, the supporting signatures that an independent candidate needed to get was close to around 20,000 votes. So you can see the unequal treatment between the two. We have taken that up with both the Portfolio Committee and the Select Committee on the basis of equality, in which we have said that independent candidate and a political party need to be treated in the same way. Now they have made that adjustment. First of all, they have brought it down somewhat, but still the supporting signatures that are required will be somewhere between, let me just close this, somewhere between 13 and 18,000 votes. So what they've done, they've equalized it, but instead of equalizing it down towards the political parties, they've brought the political parties up to the independent candidates. Now, the problem with that is, given the fact that this bill has not yet passed through Parliament, given the fact that there is going to be, most probably be a constitutional challenge, there is not going to be much time for candidates to be able to go out and register supporting signatures. They cannot do so now because the IEC still have to pass the necessary regulations. They have to design the template in which independent candidates must get their supporting signatures. So they are not going to have much time to get their supporting signatures. 13 to 18,000 votes is a lot of votes for an independent candidate to get. If anything, a political party who has got an infrastructure across a broader region could have higher votes than an independent candidate. In this case, it is the same. And we feel that it could be seen, if the barrier to entry is made too high, it could be seen as a scheme to keep the independent candidates out, where they would say that, yes, technically an independent candidate can participate in the election, but practically it's almost impossible for the independent candidate to reach the number of signatures. Now, we are not saying that there must not be any signatures. There must be some quality test for a candidate to stand. They must prove that they have some sort of support. You cannot have a situation where any person can just wake up in the morning and register to stand for the election, because there are procedures and logistics and costs involved in putting candidates on the ballot paper. And bear in mind, the ballot paper is already very long. We're looking at, in the last election, something like 48 political parties. Now you're going to have, most probably have more political parties and a whole range of independent candidates. Yeah. That ballot paper is going to be very unwieldy and problematic to handle. So one has to have some sort of barriers to entry, but it has to be reasonable. It has to pass the reasonability test. Yeah.
Have you tested this theory or this proposal, for example, where currently independent candidates are able to contest at local government election, when you say it is difficult, for example, for them to get 1,000 signatures to start with?
Yes. Well, first of all, at the local government level, the number of signatures are much, much lower, and under the current bill, I'm not quite sure how much it is, but it's a very much an achievable number of votes to achieve. But also remember, though, that bill is well established, so independent candidates can quite early at the local government level, that is. Independent candidates can quite early start getting their signatures in place. Here we have a situation where just over a year from now there's an election. There is no bill in place yet. The regulations still have to be, or the bill has to be passed. The regulations have to be drafted. The templates have to be designed. The timescales need to be put out. And only then will the independent candidates be able to start collecting the signatures. There's not going to be enough time for them to collect such a large number of votes.
In terms of aggregated votes, what is your legal opinion say?
Our legal opinion is very, very clear, and we have provided that legal opinion to both the Portfolio Committee and the Select Committee. And that legal opinion was given to us from the we commissioned it from the law faculty at the University of Stellenbosch. And that says that independent candidates and political parties need to be treated the same. Now we have a situation, as the bill stands, where independent candidates are allowed to stand in all 9 provinces, but they are not allowed to add all 9 provinces together to get a total number at the end, whereas political parties can. So what does that mean? It means that if an independent candidate fails to win a seat within the provincial list, but they do have enough votes around the country to make up the quota to get a member of parliament on the compensatory list, they are not allowed to do so because they cannot add all 9 provinces' votes together. Yeah. Whereas a small political party with an equal number of votes, who also failed to get a sufficient number of votes in a province to get a member of parliament elected, but they are allowed to add their votes up across all the countries. To get the quota for a member of parliament, they get a seat on the compensatory list. Yes. Clearly, that is unequal treatment.
Sorry, Daryl, let me just come in there. Just from that, it sounds unequal. Is there an explanation that is given? Is it just simply, no, an independent candidate cannot aggregate their votes and it just ends there? Is there a reason that is given as to why? And why is Parliament sticking to that particular reason?
We have not been provided any reasons. The process doesn't allow for that. What we have done is we have spelt out, or we have first of all given them the legal opinion. We have told them that there's inequality in treatment and why there's inequality. And we have gone further and we have provided a remedy, a way in which they can accommodate this arrangement where the votes can be aggregated. And that is simply by running the next election on the same basis as what they've been running elections up until now, where you treat the country as a single constituency, and that allows for an absolute proportionality in terms of the votes that are allocated in the end. So they haven't given us reasons for that, and the process doesn't allow for that. But that's besides the point. The fact of the matter is that they know that they know that civil society are of the opinion that non-aggregation of votes is unconstitutional, and yet they've proceeded to pass the legislation. We've again brought that to the attention of the Portfolio Committee, who are now considering it for the last time before it goes to the National Assembly to be passed through the National Assembly. We hope, and we've called on them in the statement we made today and in the submission that we gave through to them on Friday, we've asked them to please earnestly look at these unconstitutional matters, because failure to do so is going to place the whole election in jeopardy.
Yeah, but by that you mean if they don't, you will continue to challenge those clauses which you are saying are unconstitutional, and given the fact that we are now literally a few months away from the elections, that could certainly hamper the preparations and the arrangements around that.
Yes, it's not just us. There's a number of organizations within civil society that have expressed an intention to challenge it in the Constitutional Court. We are certainly considering that. We've already, in fact, had discussions with senior counsel on this matter. As I said, we've got a legal opinion that makes it very, very clear. So the issue at stake is that we as civil society, we know we have strong opinions that say that the bill as it is before Parliament is unconstitutional. Now, what do? Do we sit back knowing that a bill is unconstitutional and allow it just to happen, which will make us part of the problem in that we didn't challenge it? But the fact of the matter is that if we do not challenge it, an election proceeds, it may be challenged some months down the line, and that could put the result in jeopardy, where people say that they've executed an election that is based on an unconstitutional bill. So we have a responsibility, not that we may want to, we would say no pleasure in having to take it to the Constitutional Court, but we have no option but to test it in order to safeguard the constitutionality of our elections and to ensure that we do not have a situation somewhere down the line, just before or just after the election, where it is challenged and creates a constitutional crisis for us.
Daryl Swanepoel, let's leave it there. Appreciate your analysis and intervention tonight. Daryl Swanepoel of Inclusive Society Institute.